Para a composição da última mesa de palestra deste seminário, convidamos como presidente desta mesa o general de Exército Raimundo Nonato de Cerqueira Filho, ministro-presidente do Superior Tribunal Militar. Convidamos também o palestrante Brigadier General Jan Peter Spijk. Jan Peter Spijk é assessor do ministro da Defesa da Holanda. Em maio de 2012, foi eleito presidente da Sociedade Internacional de Direito Militar e Direito de Guerra. Formou-se pela Academia Real Militar de Breda em 1978 e em Direito pela Universidade de Leiden em 1990, onde se graduou com louvor em Direito Constitucional, Administrativo e Militar. Mestre pela Faculdade King em Londres, no Reino Unido, no ano de 2007, tendo sido aprovado com mérito. Prestou, dentre outros, serviços na Alemanha, no Afeganistão, na Bélgica e na Inglaterra. Entrou para a reserva em 1º de fevereiro de 2013. Ouviremos a palestra do senhor Jan Peter Spijk, que tem como tema o desenvolvimento da lei penal militar sobre a perspectiva internacional. Para isso, passamos a palavra ao presidente desta mesa, o general de Exército Raimundo Nonato de Cerqueira Filho, para dar as boas-vindas ao nosso palestrante.
É com grande satisfação e honra que estou aqui presidindo a última palestra do seminário e, particularmente, o general Jan Peter Spijk, é um nome um pouco complicado, mas já colocaram aqui como soletrar, então ficou mais fácil. Mas é uma honra pelo currículo do general, tem muita experiência na área militar, e eu tenho certeza que a palestra dele, como uma palestra de encerramento, será de alto nível. Então, sem mais delongas, eu passo a palavra ao general
Spijk.
Yeah. Spijk.
Good. Thank you very much. A very good afternoon to you all, ladies and gentlemen, your excellencies and generals. It is a great pleasure for me to be here, and I thank you very much, General Cerqueira, for the invitation, and also Madame Vice-Presidente Maria Elisabeth. We are most honored also because the International Society for Military Law and the Law of War, of which I will speak in a minute, is for the first time here represented in Brazil.
Excuse me, John. Just a minute, I'm sorry. Just to make it closer. Better.
Okay, I hope this is better. Let me try to start on a light note. Yesterday we have learned from Professor Fidel that in the United States, King George III is still very much honored. We in the Netherlands don't do that because we have a long history of conflicts, especially in the 17th century with the English, so we do not honor King George III. We do honor, however, Queen Maxima. Queen Maxima from South America, who was very recently, she became queen, together with her husband, William Alexander, who became king of the Netherlands. And I'm not here today in a Dutch capacity, but since I'm here, it's nice to look at those ties. I thought for a while about putting up a picture of Queen Maxima. As yesterday Professor Fidel put up the picture of King George III. But I must say I decided against it, because I'm sure that at least half of the audience would only be looking at the picture of Queen Maxima. But what we did is, as you can see, the background of the slide is orange. And the Queen Maxima is now also a member of the house, the royal house of Orange-Nassau. That is the name of our royal house in the Netherlands. And I found out while traveling to Brazil that our ties go back a very long time. Because it was a distant relative, a Juan Maurice de Nassau, who was governor of Recife, if I pronounce it correctly, for 7 years, 1736 till 1744, if I remember correctly. And later on, we even became neighbors as countries for 300 years. As we all know, Brazil borders nearly every country on the South American continent, and one of those countries is Suriname. And Suriname, as you know, was Dutch until 1975. And now I promised to our American colleagues to mention how that all became. You may know that the Dutch actually were the first owners of what is now called New York and the wide area around it. And we called it at the time New Amsterdam, as you can imagine. But after a little bit of strife and 3 wars with the English, we decided to hand over New Amsterdam. At the time it was even called New Orange for a short period. But in exchange we got Suriname. Some people think that was a bad deal. But here it is. In deference also to Professor Manuel Gonçalves Ferreira Filho, who did the brilliant first introduction on this seminar, I thought that it would be a good idea to go back to Rome with you as a start. And that is an important quote. And some of you may think, well, the quote is not completely correct. That is right. Because the correct quote of a very famous orator named Cicero, who lived at the time of the dictatorships Professor Gonçalves described, wrote many oratios, as they were called, and one of those oratios was called Pro Milone. And in that oratio you will find that very famous quote, et enim inter arma silent leges. The laws are silent inter arma, yeah? Beyond, in the context of arms or in an armed conflict. One of his most famous quotes. What I did is I changed that quote a little bit. And what you see on the screen now is inter arma vigent leges. And the word vigent, the Latin word vigent, means rule. So what it now says that inter arma, the laws indeed rule. Because that is the theme, I think, for a conference as this. And it is also my personal in 2 ways. That is that in the situation of armed conflict, we indeed should strive for the laws to apply, and we, you and I, as a legal community, have a very important role in bringing us there, and I'll get back to that later. And there is a second perspective with a little bit of linguistic flexibility, because inter arma then could read for those people within the armed community, in the community of the armed forces, legal rules should apply. And I would argue specific legal rules should apply. And these are the themes that I would, in this closing speech, would briefly want to share with you, to discuss with you. 2 perspectives, and those 2 perspectives are very close to the Society for Military Law and the Law of War. And Madame Vice-Presidente Ministra Maria Elizabeth has asked me to say a few words about the Society, and you see the logo there on top of that slide. The International Society is a Brussels-based organization, Brussels in Belgium, as you know, and it already exists since 1957. About 1,000 members worldwide, and the aim, the goal of the society is rather idealistic, one could say. It is to study, but foremost to disseminate the knowledge on those fields of law. So military law, and as they called it 57 years ago, the law of war, we would now call it, I think, the law of armed conflict or international humanitarian law. And it is a platform for people like you and me, military legal professionals who are interested in these fields. And so we try to literally spread the word and to spread knowledge about these fields of law. And we do that in several ways. The main and most important way, I think, is organizing conferences and seminars for these legal professionals, essentially also all over the world, where we gather rather large numbers of professionals like you to discuss these themes. And in the very recent past, we have been to Beijing in China, we have been to Namibia, to Tunis, to Quebec City, to Latvia, Riga, and next week, Wednesday, I will stand in Chile, in Santiago de Chile, where I will open a conference together with my good friend, Brigadier General Waldo Cáceres Martinez, who is the head of the legal services of the Chilean army. And then we will discuss for 2.5 days also the topics that were relevant in this specific conference. I invite you to have a look in your spare time at the website of the Society. You will see the address there on the screen. And of course, I invite you to become member. It's already trilingual in English, in French, and in Spanish. And when we get enough Brazilian members, I promise you, we will do a Portuguese page. Okay, going to the content, and I go to my text. So 2 perspectives, and the first perspective that I would like to discuss with you is the perspective of the evolving legal spectrum in which legal advisors to the armed forces have to equally evolve, so to say. And then in the second part of my contribution this afternoon, I'd like to address a topic very central to this conference, the developments in military justice systems, and I will try to do so from a European perspective. I think I am the only European in the audience this afternoon, so maybe that is a good idea. But first of all, the evolving role of the legal advisors in that evolving legal spectrum. And since this conference takes place in the Americas, it is good to note, and Dr. Richard Meyer did so already in his presentation, that the first legal advisor with the forces was an American one. In 1775, to be precise, General George Washington appointed William Tudor as the legal advisor, as the judge advocate of the Continental Army, and later he became the first judge advocate general. His duties did not reach down to the operational level. It would take a long time before it developed all that way. And for that, I make a significant jump in history, and I go to 1949, where the Article 82 of the Additional Protocol 1 to the Geneva Conventions came into being. And as you all aware, that prescribes that legal advisors are available when necessary to advise military commanders at the appropriate level on the application of the conventions and the protocol and on the appropriate instructions to the forces. Today, all the countries that I now have specialized legal advisors attached to those armed forces. Most of them are in uniform, but sometimes, and it was already noted, for example in Germany, they do have the legal advisors, but for historical reasons, they walk in civilian clothes in peacetime. I'd like to mention today with you 2 major developments, and that is in the first place the continuous process of further development of the body of law called the law of armed conflict, otherwise called the international humanitarian law. And when we investigate that the past century and specifically the past decades, the scope of military operations has changed enormously. was a rather stable period in the Cold War, one could argue. But nowadays, the armed forces, including the Brazilian ones, and I will come to that later in a moment, are used for an array of activities in a very complex environment. We see an increasing role of the military in essentially civilian operations, like humanitarian assistance, now very actual also here, I understand, humanitarian assistance operations and drug interdiction programs, but also an essential role in one would call nation building. From a military law or a military legal perspective, this has been an era of huge change, in which in the importance of legal norms in this broad spectrum of activities increased dramatically. The legal environment of current military operations now involves, as a rule, the legal frameworks of multiple states and of international organizations like the United Nations and the bodies of the UN and the special missions of the UN. And not only the scope of those legal norms has increased enormously, also what I would call the legal parameters have also become more and more refined. And this all leads to an increasingly complex environment where also media scrutiny, as you know, as we call the CNN effect, is very important for our troops in the field. The effects of all these developments in context are multiple in character, and I will mention a few. In the first place, applying the rule of law in an international context in military operations is no longer the prerogative of military commanders. It often has become very much a political issue. I mentioned the complex nature of the operations in Afghanistan, where ISAF coalition forces have to operate in a very difficult legal, nearly vacuum, combating Taliban warriors on the one hand and assisting in nation building on the other hand, in a nation with virtually no rule of law. And those political and military and legal complexities are most visible in counterinsurgency. And that is a topic that is also, I think, very relevant for the situation for some countries here in the Americas. Situations of counterinsurgency where the counterinsurgents are obliged to uphold, the government troops are obliged to uphold the principle of legitimacy and the rule of law, in spite of the insurgency strategy to apply unlawful tactics such as perfidious acts and terrorism. And these acts may provoke the counterinsurgent, the government units, to resort to similar unlawful and immoral behavior, which of course is precisely the goal and the objective of those insurgents. And obviously the provocation should be resisted because, as we know and as experiences learn, that the populace in casu will only accept counterinsurgency measures when they are perceived as rule of law based decisions. And even when the measures of the coalition forces are legitimate by the standards of a UN mandate or a law of armed conflict perspective, they may not be implemented because of the risk of collateral damage, which in itself could have been fully acceptable under the norms of proportionality. And this reflects the reality that the end state that matters most is not a military one, but a political one. As the former ISAF commander, General Petraeus, put it, who described the essential question of when to go ahead with a certain operation, he said, will this operation take more bad guys off the street than it creates by the way it is conducted? And last but not least, and very important in the context of this seminar, the issue of accountability in relation also to this court. You're very much aware that of the developments in the jurisprudence on command responsibility in the special courts in The Hague, where I come from. But I'm convinced that grave breaches and war crimes will also be judged in the regular military courts that we have been discussing these past days, maybe with the exception of Colombia, as we learned this morning in the presentation of Professor Javier Rincon. This accountability issue relates to the refinement and the broadening of the applicable norms, which are essential to know for our troops in the field. Legal norms in law of armed conflict and international humanitarian law. And when we look at the Geneva Conventions first, we see that broadening in the additional protocols and also that refining. And most of those norms, specifically of the additional protocol 1, although not ratified very broadly, have now become customary law. I'd like to mention, before I conclude this first part, 3 developments, legal developments, which are interesting to know and which truly affect the operations of our troops in the field. There has been published recently the Manual on Air and Missile Warfare, a Harvard initiative, which brought together a distinguished group of legal experts under the well-known leadership of Joram Dinstein. And this manual and the accompanying commentary describe in great detail the black letter rules and the legal discussion pertinent to the use of the air weapon in modern conflict. Very actual for today is, it was mentioned this morning in another context, is cyber warfare. And an American, Professor Michael Smith, who currently teaches as Dean Law Faculty at the US Naval Academy in Newport, was responsible for the publication of a book which describes important new questions on cyber warfare. And thirdly, the discussion on the simultaneous applicability of human rights law and the law of armed conflict, and how that interaction between those bodies of law should be addressed. And this is getting more and more attention, specifically in the areas of targeting and so-called operational detention. And this, ladies and gentlemen, is not an academic discourse, because as you heard this morning in the presentation of Professor Javier Rincon, in this part, in your part of the world, very close by in Colombia, where the regular forces are fighting the FARC guerrillas, that is a question that occurs every day. Because when you look at it with a scholastic view, so to say, one could identify a certain province where then the government rule of law would apply, and then the human rights law approach would be valid, while in another neighboring province, the situation, which would be qualified as armed conflict, could arise, and then law of armed conflict norms should apply, with a totally different way of looking at the effects. And as we learned today in Colombia, the soldier does not know, with the problem of schooling and education, the soldier does not know which law to apply. And even the commander probably will not precisely know which law to apply. And this is also more in general not an academic question, because with that refinement and with the broadening of the legal norms that should be applied by troops in the field, ladies and gentlemen, there is a big risk that if something goes wrong, they will end up here in court. And I would argue with you that it is the responsibility of this legal community as it sits here today that we definitely prepare our troops for those missions so that they precisely know which legal norms will be valid. And for Brazil, that is also a very relevant aspect. I note with you that Brazil is in the top 20 of United Nations troop suppliers. Currently, as we speak today, more than 2,000 Brazilians are abroad, military experts, regular troops, policemen, and they can and have to operate in these rather difficult circumstances. So, an important topic, I would suggest. Let me move to item number 2, closer to the penal perspective, looking at the military justice systems. And that is very close, as I explained already, to the heart of the International Society for Military Law and the Law of War. And let me begin by saying that we, as a society, obviously respect all the choices that national governments make with regard to their military justice system. That is a national decision to make. And it is the position of the International Society that it is advisable to have a military justice system. And to substantiate that position, I would like to quote from a Canadian Supreme Court decision, being here in the Americas, already mentioned, I think, by Chief Judge Baker in his presentation, and also, I'm sure, by our Canadian colleague, the Supreme Court decision R v Généreux. And let me quote that text. The purpose of a separate system of military tribunals is to allow the armed forces to deal with matters that pertain directly to the discipline, the efficiency, and the morale of the military. To maintain the armed forces in a state of readiness, the military must be in a position to enforce internal discipline effectively and efficiently. Breaches of military discipline must be dealt with speedily and frequently punished more severely than would be the case if a civilian engaged in such conduct. Special service tribunals, rather than the ordinary courts, have been given jurisdiction to punish breaches of the Code of Service Discipline, and recourse to the ordinary criminal courts would, as a general rule, be inadequate to serve the particular disciplinary needs of the military. There is thus, therefore, a need for separate tribunals to enforce special disciplinary standards in the military. End of quote. This particular decision obviously lists arguments related to the Canadian system, but in a more general sense, we can identify the need for specific rules and regulations related to the specific military standards and military tasks and the circumstances under which these tasks are to be executed. In addition, the requirement for a judicial system which is geared to speedy but nonetheless fair and high quality judgments to ensure discipline and operational effectiveness within the armed forces. Commanders, as far as disciplinary offenses are concerned, and prosecutors and judges in case of criminal offenses should be qualified to appreciate and to judge behavior of military personnel in the context of those military institutions. And also, and I think this is particularly important, to judge in an operational context, because those operational contexts are specifically hard to understand, I would submit, for civilians who have never had any experience in that field or who are not related on a regular basis to the defense operations. And an extra argument is that because different legal standards may and will apply, for example, international humanitarian law standards in those operations. Well, in this seminar we have learned extensively about the United States justice system, the Brazilian system, obviously to be mentioned first, the Canadian and the Colombian system, all with their own interesting and own specific characteristics. And I can assure you, and we did 2 comparative law conferences a number of years ago, the last one quite recently, I think 1.5 years ago, on the island of Rhodes in Greece, that the diversity in military justice systems is of a global character and fully matches the diversity in national anthems, completely the same. And to paraphrase Dr. Meyer yesterday, who was talking about skinning a cat in the military justice way, I can assure you that there are 193 ways to skin a cat, as many countries as there are in the world. I'm now slowly going to move to the European perspective. Some general characteristics of the 193 can be identified, and those are related to the nature of the original legal systems. And although the gap is becoming smaller, we still see major differences between countries with a common law background and countries with a civil or Roman law system. And important aspects in this respect, and we discussed those in the past 2 days, are the role of the commander in common law countries, much more visible and of a determining nature, more visible and more determining than in civil law countries. I reference the presentation by Professor Fidel in that respect, where he explained that background. And the dichotomy between the ad hoc military courts on the one hand in the common law countries vis-à-vis the standing military courts in the Roman law countries. In the past decades and also currently, as we have heard even today, many military justice systems are under public scrutiny. And let me then try, as I already announced, to add a little perspective from across the Atlantic and offer a few European and other examples. And those are not all positive, I can assure you. In Belgium, to begin with, the neighboring country, the country where the society has its seat, the military courts in peacetime have been completely abolished. In the Czech Republic, the military courts in peacetime were abolished in 1994 already. In France, and this is a recent development of last year, they have abolished the military courts as such, and they have introduced so-called military chambers in a number of provincial courts. But they are only military in name, because there's no military individual to be seen in those courtrooms. These are all civilian justices. That is for offenses applied, or committed, I should say, offenses committed in France. For the offenses committed outside France, there is a Tribunal Militar in Paris. But the Tribunal Militar and all its functionaries are civilians. So the military aspect has disappeared. And in my own country, the Netherlands, the court-martials and tribunals that we had, very, very comparative to the Brazilian system, were abolished in 1991 already and replaced by a system where we now have a military chamber at the single court in the Netherlands, which will deal with all military offenses of all military personnel. And in that military chamber, you see 2 civilian judges and a military one. And these are very militarily versed judges, one could argue. Norway, military prosecutors, but often civilians, prosecute military offenses before civilian courts. And also in other countries, I mentioned Canada, and we discussed that at length in the presentation, but also Australia, and as mentioned, Taiwan, changes are underway, being contemplated, etc. From the perspective of the military, and I speak from experience, there often seems to be a deep resistance to change. And that deep resistance is often rooted in a deeply felt concern about the interests of the country in general, and the military and its commanders in their unique responsibility as standard bearers for the requirements of discipline and operational effectiveness. And you will recall the arguments made also by Colonel Maxwell in this respect. And often there seems to be a conviction, a strong conviction, that all change will be for the worse. And I would suggest today to the relevant authorities that when confronted with calls from a democratic society that a military justice system has to change, that it is particularly wise to do a very careful analysis, not unlike an operational commander who would analyze all relevant factors like the opposing forces, like the weather, like the terrain, before embarking on an operation. And not to do so is, in a certain sense, at one's own peril, is the lesson that I have learned when looking at the developments in the European context. Sometimes there is a risk of losing the military justice system altogether in its entirety. The United Kingdom offers an interesting example in this respect, and I come back to King George III, because that system was under close scrutiny of the European Court of Human Rights. You have, of course, the Inter-American Court of Human Rights. We have the European version of that, and that is a rather strict court, I can assure you. It is located in Strasbourg in France. The common law-based military justice system of the UK had to be changed, that character had to be changed completely. And it was interesting to learn during a recent seminar led by Professor Fidel in Yale University that those major changes now seem to have been, I underline and emphasize seem to have been fully accepted by the senior military leadership and rank and file alike, and that the operational effectiveness of the UK armed forces has not diminished. What are the key conditions for an adequate military justice system as defined by that European Court for Human Rights in Strasbourg? And let me mention here that this court consists of the most senior judges of all European member states and other states that are parties to the Human Rights Convention, the European Human Rights Convention, and would, for example, also include Turkey, which is not a member of the European Union. In a series of judgments on the basis of procedures brought forward by mainly Dutch and British citizens, the court has established a set of norms based on the requirements of, I quote, a right to liberty and security, a fair and public hearing, and an independent and impartial tribunal established by law. And the norms can be summarized as follows. And I begin with a famous ruling which also figured in the presentation by Chief Judge Baker, the Engel ruling, going all the way back to 1976. And that goes back to the time where we, in the Netherlands, ladies and gentlemen, had a huge conflict in society. You can recall the protests in Paris in the streets with the demonstrations of the protest. Well, we had similar developments in the Netherlands, in Amsterdam and the big cities, but also in the military. And at that time, we still had a conscript system, and those conscripts action groups, so to say, managed to convince the political leadership as a first move that it would be wise to have no longer the hair regulations. And from those times, some of you may recall, you had the Dutch soldiers, the male soldiers, with hair like this, longer than most of the ladies here in the audience this afternoon. They were well disciplined, most of them, but this was an awesome, picture, so to say. This Mr. Engel was put in jail, essentially, for a period of about 10 to 14 days. And it was like a jail sentence in the sense that the door was locked behind him and he couldn't get out in no way. And there was, and this is the important part, there was no right to appeal that decision to a higher authority. And there, the European Court in 1976 ruled it cannot be the case that when we have a deprivation of liberty by arrest or detention, that individual shall be entitled to take proceedings by which the lawfulness of his detention shall be decided speedily by a court. And it cannot be the case that military commanders deprive an individual from his or her liberty, which in its material execution is identical to a confinement in a jail. Then I moved to the UK, and there is a very famous decision called the Findlay decision in 1997. And there are a few aspects of the Findlay decision that are relevant, I think, for us this afternoon, and I mentioned the first one, and that goes to the discussion about the American system. A military tribunal of which the convening officer has determined the composition and of which all members were lower in rank than the convening officer, and the decision of which is subject to confirmation by that same convening officer in his role of confirming officer, is not an impartial and independent system as required by the convention. That was Findlay in 1997. And then about the independence of a president of a court-martial, and now we're in 2003, and the UK had already changed materially. The court ruled that in court-martials the permanent president should be truly independent of the chain of command, and the ordinary members should be bound by strict regulations concerning confidentiality of the meetings and a comprehensive guide on how to perform their role. That was the Cooper ruling in 2003. And in the Cooper ruling, you see also the presence in a court-martial of a civilian with correct qualifications and with a pivotal role in the proceedings constitutes an important safeguard and a very significant guarantee of the independence of court-martial proceedings. There's another ruling of the European Court, and that relates immediately to what the position is of Judge Baker, and as he explained it, that at higher levels, and certainly at Supreme Court levels, the court should be completely civilian. As said, the British system is now based on these principles while having retained its original role as guarantee for operational effectiveness. And seen from a European perspective, these principles seem to reflect not only the opinion of the court, but also the opinion of, I think, the general public, which safeguards in military judicial procedures should apply. And those same notions now seem to influence the debate in both Canada and Australia. But as I said, it is for national governments and parliaments to decide how to structure their national military justice systems, taking into account their national requirements, legal notions, and culture. Concluding, I would say, ladies and gentlemen, when I go back to my first part of this presentation this afternoon, that we in the legal community, as we are here, as military and as civilian legal professionals, we are responsible for taking care that all our military personnel that is to be deployed is well prepared for that very complex legal context in which they have to operate. And my second conclusion is we should cherish our military justice systems. We should very much take care of them because they are highly important for the well-functioning of the military forces, as was argued in this seminar by several speakers. And I would also argue that it is necessary to adapt when the time is there, because you have to move forward. And as I began with the Roman speaker Cicero, the orator, I could end with a Greek philosopher to add another European perspective, and that is with the words pantare of a famous Greek philosopher, which means everything flows and everything will change. I wish to thank you, General Sakea, for the opportunity to speak here. As I explained in the beginning, I have become a professional organizer of conferences and seminars on military law topics, and I wish from that position to compliment General, you and the court, and specifically the organizing committee led by Madame Vice-President Maria Elizabeth for this fantastic program, because I seldom see such a broad program with so many perspectives from all sides, even the discussions that we had today on the economic side and how we should develop as a society in a wise way, so to say. So this is an important seminar which certainly transcends the borders of the Americas with its topics. So a huge compliment. And with that, I thank you very much for your attention. Thank you. I don't know whether there's time for questions, but I'd be happy. Yeah. Sir.
Congratulations.
Thank you very much.
Senhoras e senhores, acabamos de assistir uma excelente palestra do general Spijk, que nos traz uma reflexão. São as mudanças das justiças militares no mundo, particularmente após o fim da Guerra Fria, o Muro de Berlim, e vários países que pertenciam à cortina de ferro, vamos dizer assim, se abriram para o Ocidente, e houve uma série de modificações da justiça militar. Nós ainda aqui no Brasil mantemos a nossa tradição, até porque a nossa justiça militar ela faz parte do Poder Judiciário, talvez diferente de grande parte dos países que tem corte marcial. Nossos julgamentos, como todos sabem, seguem toda a sistemática do Judiciário brasileiro, não são diferentes. Então tem essa particularidade. A composição dos Conselhos de Justiça e aqui do próprio Tribunal é o escabinato, é o militar com o juiz togado. E temos que analisar também um aspecto importante, somente foi abordado com ênfase na Europa, é outra cultura, nível de vida mais alto. Então, cada vez que o país vai atingindo um nível de desenvolvimento, realmente há uma descompressão em relação às cortes marciais. Entretanto, nós não estamos nesse nível ainda. E como bem falou o palestrante, as nossas Forças Armadas, elas participam no dia a dia da vida do país. Nós cumprimos inúmeras missões em atendimento à população. Até, vamos dizer assim, a nossa principal missão é a defesa da pátria, mas cumprimos e treinamos muito mais para outro tipo de missão, que em apoio à população. Temos diversas missões, não vou enumerar aqui, porque eu fui o comandante do cotel, monitorava todas as operações. Inclusive, nós temos tropa no exterior, é o caso do Haiti. Aproximadamente, nós dobramos o efetivo, tendo em vista o terremoto que ocorreu naquele país. E o trabalho está sendo executado muito bem. Nós temos pequenos casos envolvendo militares na parte da justiça militar. Muito pouco. Mas já visto o alto nível de treinamento do pessoal e eles são orientados permanentemente como proceder com a população. Os desvios de conduta são mínimos. São mínimos. Preservando principalmente a hierarquia e disciplina. Então, eu gostaria de cumprimentar o general Spijk pela excelente palestra e fica a reflexão de todos o que foi falado aqui. E vamos dar agora início ao debate. E aquele que quiser fazer pergunta, não tem comigo o papel da pergunta, mas poderá levantar o braço e nós passaremos o microfone. Professora Patrícia.
Boa tarde. A minha indagação é sobre todos esses estudos que estão sendo realizados na base da legislação, se há algum estudo específico quanto aos procedimentos relativos a esses estudos, ou seja, a lei vai precisar de uma regulamentação e dos procedimentos também. Nós temos o processo judicial, mas vai existir os procedimentos abaixo do processo, de como esse processo vai dar. Se existe algum estudo que vise um objetivo, um melhor procedimento antes de mesmo ser instaurado o processo.
could you maybe clarify your question a little bit? Maybe I lost something in the translation, but...
Sim, sim. O processo, ele segue um ritmo com base legal. Então, geralmente, você tem um código que prevê todas as partes do processo. Mas o processo necessita de procedimentos. Esses procedimentos é que vão dar vida à maneira de caminhar do processo. Então, como há todo um estudo sobre o arcabouço de legislação sobre a jurisdição militar, se existe também um estudo como agilizar os procedimentos de uma forma de uniformizar para atingir uma maior eficiência e qualidade do próprio processo.
Thank you very much for the clarification and for this interesting question. We have indeed, as I explained already, conducted an investigation into, I think, about 60 military justice systems, and I would gladly share the results of that investigation with you. But what you see is that it is very much those procedures that you refer to are very much dependent on the national choices. You see in some countries that the processes and procedures are essentially copies of what is done in civil, penal justice, but in other countries there are totally different systems, and it then relates to the specifics of the courts that are in place. But I am sure that a more detailed study, and I would be willing certainly to embark on that, I should say, can help us in identifying lessons by which we then could improve our national systems. So thank you.
Obrigado, doutora Patrícia. Passaria a palavra agora ao doutor Javier, professor Javier, da Colômbia.
General, a minha pergunta é a seguinte: o senhor falou de uma situação particular ou de uma solução, talvez, para aplicar num país o direito internacional humanitário e o direito dos direitos humanos, ou as regras dos direitos humanos. Você falou que ao interior do país se podia escolher umas áreas onde ia ser aplicado o direito internacional humanitário e outras para aplicar os direitos humanos. Qual seria o critério para determinar onde vai ser aplicado o direito internacional humanitário e onde os direitos humanos, pensando, logicamente, num conflito interno, num conflito irregular, onde você tem dificuldade para claramente determinar qual é a região, vamos falar, livre de conflito.
Yeah. Thank you very much, Professor, for this rather challenging question, because this essentially goes, as you know, to the definition of an armed conflict. When do we have an armed conflict? When do the rules and the laws of armed conflict apply? And then, indeed, we look at several criteria, and I mentioned a few. One of them is the intensity of the violence that is going on. And that in comparison to a single shooting, but is there, for example, something that can be seen as nearly a state of war, for example. We look at the character of both parties. Yeah? And in the example that you obviously, I think, refer to, where one would have government troops on the one hand, but how is the organizational degree, for example, of those adversaries? Are those single individuals, or is there a form of an organization? Is there a form of a command structure? On the other hand, when we would look at the situation of human rights applicability, that would be more in the context of a law and order situation. A situation where the national government, generally speaking, has control over what happens on the streets, and where, generally speaking, a police force could maintain law and order. Well, there are more criteria, but this is, let's say, the broad picture. And the problem, obviously, is that we are talking essentially about lots of very gray areas. It is very hard to define, and one could argue that over a rather limited period of time, the qualification could possibly change from A to B and back. And that is the problem, and I already said, I think, Professor, in my presentation, that it is a kind of a scholastic approach and rather hard to implement. But we cannot deny that this is a discussion that is really getting more and more weight. Thank you.
Mais algum debatedor? Doutor Edmundo, por favor.
Queria cumprimentar o conferencista, sobretudo enfatizando uma circunstância que o expositor revelou, que para mim foi muito gratificante, ou seja, de que o conferencista é hoje um coordenador profissional de seminários, de congressos, visando o estudo e a reflexão sobre direito penal em várias partes do mundo. Por outro lado, a outra indagação, que a rigor seria apenas um pedido de informações. Eu, com muita honra, já entreguei e integrei o quadro da Sociedade Internacional de Direito Penal e da Guerra. Já participei, inclusive, de um congresso em Ankara. E eu gostaria de pedir informação acerca da representação da sociedade aqui no Brasil. Que ela já teve uma representação, a sociedade, que, por sinal, funcionou muito bem e, inclusive, deu uma modesta contribuição aos debates internacionais. Então, eu gostaria de saber como é que se encontra a sociedade estruturada no Brasil hoje. E a terceira indagação se refere aos atos procedimentais que levam ao encaminhamento e o desenvolvimento dos processos tendentes à realização da justiça. Muito embora o eminente palestrante tenha se referido a 193 formas de se extrair a pele do gato, mas creio que, em razão de tratados internacionais, convenções internacionais, ou mesmo tendo em vista a estrutura do direito do Tribunal Penal Internacional e da Corte Europeia de Direitos Humanos, da Corte Interamericana de Direitos Humanos, em razão dessa estrutura internacional, creio que alguns modos de realização dos atos processuais tendentes a atender ou a responder ao devido e justo processo penal, alguns modos devem estar contemplados em vários, ou quase todos, pelo menos em vários, estatutos processuais, tais como o amplo direito de defesa, o princípio do contraditório, pelo menos esses e outros mais, do juízo natural, e muitos outros decorrentes do próprio conceito do devido e justo processo legal, como isso se passa nos diversos países.
Very much for your questions. The brief answer to the first question is that, as far as I know at this moment, that we have a few individual Brazilian members to the International Society for Military Law and the Law of War. We are very much happy, of course, with those members. But it would be possible to organize what we call in our terminology a national group, where you would organize from the legal community, which is present here today, for example, those people that are interested to participate in that platform, as I called it, a platform to exchange ideas and views on this topic, the military justice system, but also the broader topics as we have referred to earlier. And I would applaud, obviously, an initiative here in Brazil to bring together a Brazilian group with its own leadership and its own activities. And fora like these could be used then for strengthening the ties within the group. But as is done in many other countries, I would advise to also organize other activities and reach out to other specialists in the field. And I offer to you today all the assistance that you would need in setting up such a group. So, fully welcome in that respect. As to the second question, obviously I cannot this afternoon, it would take weeks to give an overview of the systems of the 193 countries. That is evident. But what I wish to say is that, yes, I agree, and I think it was implied in the way you phrased the question, I agree that it is possible to identify, let's say, general norms. And when we look at the jurisprudence of those different international courts, let me qualify them as international courts, then you can draw a line in the sand. And there are indeed basic principles that should be applied. And we could make a list of those basic principles. But having said that, you also see in the rulings of those different international courts that national authorities, like your Brazilian national authorities, get a lot of leeway. There is a lot of room to maneuver. When those principles are guaranteed, then the rest of the building, the rest of the system can very much be modeled to, in this case, the Brazilian needs. So that, I think, is in essence the answer to the question, and I do subscribe, I do agree that it is a good idea to make that identification of those broader norms as a starting point for a discussion on how do we go from there. Thank you.
Bem, chegamos ao final. Vamos realizar os agradecimentos ao general Spijk e posteriormente fazer um encerramento do seminário, que nós também teremos uma atividade mais tarde. O general Spijk nos trouxe uma série de informações que serão bastante úteis a todos que participaram do seminário, e realmente ele fez o encerramento do seminário com uma palestra de alto nível. Então, só temos a agradecer. E, para reconhecer esse nosso agradecimento, gostaria de passar ao general Spijk uma lembrança do Superior Tribunal Militar. E, ao mesmo tempo, solicito a todos uma salva de palmas.
Neste momento, o seminário presta homenagens ao palestrante, o Brigadier General Jan Pieter Spijk, na pessoa do General de Exército, Ministro-Presidente do Superior Tribunal Militar, Raimundo Nonato de Cerqueira Filho.